to refix. Because it takes time for the orders to be checked and then uploaded, no? In view of the foregoing analysis and conclusions, this court is of the view that the learned trial court has not committed any error either in law or in fact in convicting the accused. Appellant appeal stands dismissed.
Lordship, much obliged, Lordship.
May I please, Your Honor?
Yes.
Your Honor, I would mention item number 10.
Item 10, yes.
My Lord, I am seeking adjournment for today.
For today. Heard learned counsel petitioner
For
appellant.
respondent, yes.
Or
For the appellant.
Okay. Okay. Heard learned counsel for the respondent, Mr. Such and such, who prays for adjournment for the day. The prayer is not objected to by the learned counsel for the appellant, Mr.
D. Laj.
Such. Your names, yes. So accordingly, this is the matter next week,
After 2 weeks, ma'am.
after 2 weeks. Yes.
Most
All right.
Your Lordship, I beg to mention item number 12. Kindly matter may be adjourned for today. I have already taken the consent from opposite party.
Heard learned counsel petitioner. For the
Yes, Your Honor, I'm for the
Mr. Such
petitioner.
and such,
Yes.
who prays for listing the matter on another date, as she has some difficulties today. So learned counsel for the opposite party has no objection.
Madam,
List the matter when? Next week,
Your Honor, after 2 weeks.
after 2 weeks. Yes.
My Lord, my appeal may be recorded.
Yes.
I'm appealing on behalf of OPADA, standing counsel for
Mr. Such and
ACB.
such, yes. Appearing for such and such is also present. On behalf of OPADA, no?
Yes, my Lord.
Yes.
Obliged, Your Honor.
Item number 2.
ये ना दूसरा pages हम side करेगा ना temperament pages.
My Lord, it's a regular bail application, and in fact, it's a very short matter. This matter was pending before the Learned Session Court, and I had to withdraw the petition for a reason that there was a statement from the IO stating that the CD has been retained by the Honorable High Court in respect of some other co-accused. That is the reason I have withdrawn the petition and I have filed this petition, my Lord. And I suppose, my Lord, the CD is with the Learned PP.
Yesterday we have received from the registry, my lord. In one anticipatory bail, my lord, which has been made absolute. In this case, my lord, the CD was retained by this honorable court, and we have it has returned as yesterday only, my lord. I have the copy of the.
Otherwise, my
No,
Lord,
no, but the applicants are different.
Yes, absolutely.
Different persons.
Yes,
isn't
ma'am.
it?
otherwise the co-accused, 2 other co-accused has been released on bail, and I'm under custody since last 33 days. And in fact, I'm challenging the legality of the remand itself, my lord. Without even perusing the case diary, the remand has been granted. And moreover, my lord, may kindly see, I have, in fact, 2 minor daughters, and they are totally dependent on me. And the investigation part is almost over, my lord. And all the sections are bailable, my lord, except one section, and wherein the punishment goes up to only 3 years, my lord. So therefore, I'm praying, my lord, kindly consider my application on this count itself, on the parity or.
Co-accused?
Yes,
Really?
my lord, co-accused has been granted. Well, my lord, the plague mark is there. The role of the accused has been reflected by the IO, my lord.
Let's see.
Although there is no any comment against this accused because the bail application was against the other accused. But your lordship will see, I highlight the name of the accused, my lord.
Ringu Ratte, na?
Yes, my lord.
Ringu Ratte. Who physically attacked him and the scene to be the person who did the matter. Ringu Ratte. So this Michael, Dajo, and the others, they are.
Yes, Michael Tajo, my lord, anticipatory bail has been made absolute by this honorable court. And the other co-accused whose name is,
Jay
yes,
Shankar.
he has been granted bail, they have annex the order, my lord.
Page number 35, my
Page
lord.
number
My
35,
petition.
wherein the Honorable Judicial Magistrate First Class has granted bail, my lord. So is granted by the JMFC, my lord. The offense, meaning thereby the offense is not more than 7 years, my lord. It's 3 years extended.
Okay. Learned counsel for the petitioner should such and such. Stop. Para the instant as well as the learned additional PP Mr. T. Stop. Para the this instant bail application has been filed under section 483 of the BNSS, seeking regular bail in respect of the alleged accused Ringu Rate, you see from the cost list, okay, who was arrested on 28/12/2025 in connection with Itanagar PS case number 185/2025, registered under sections 126 clause 2 /118 clause 1 /324 clause 3 /3 clause 5 of the BNSS. Stop. But the case of the petitioner is that the accused was arrested on 28/12/2025 in connection with the aforementioned case, and he has been in custody since then. Stop. It is also stated by the learned counsel for the petitioner that the offenses under which the accused person has been booked are not serious offenses and carry a maximum of 7 years.
3 years, my lord.
Maximum of 3 years imprisonment as punishment. Stop. It is also submitted that subsequent to the arrest, the alleged accused was produced before the JMFC Naharlagun on 28/12/2025, whereupon the magistrate was pleased to remand the accused to police custody for a period of 3 days. 3 days or
5
5
days,
days?
my lord. 5 days.
Period of 5 days. However, it is submitted that the learned magistrate had granted the remand mechanically solely on the forwarding report of the investigating officer without perusing the case diary or recording any judicial satisfaction as to the existence of a prima facie case. And therefore, it is stated that the order dated 28/12/2025 granting police remand is ex facie illegal. Stop. Para another ground taken by the learned counsel for the petitioner is that the co-accused have already been granted bail by this court or by okay.
One by the learned judicial magistrate first class
By
and
the
other
learned
one by this
judicial
honorable
magistrate
court.
first class and by the learned sessions judge UPIA.
No, by this honorable
By
court.
this
my lord.
honorable court,
By
my
this honorable.
Anticipatory bail, my lord.
Oh, okay. One by the judicial magistrate first class UPIA and pre-arrest bail by this court.
Yes, ma'am.
So, and the orders granting bail dated the orders, what are orders of the bail? Bail orders dated
That is the JMFC order, my lord.
5/6, I think. 5/1.
That is the anticipatory bail granted by
5/1/26, my lord.
5/1/2026 and 19/1/2026 have been produced by the learned counsel. Stop. Accordingly, the learned counsel has prayed for release of the present alleged accused on bail, as the offense with which he is charged is not a serious offense, and moreover, on the ground of parity also, as the co-accused have already been released on bail. Stop. Para. The learned additional public prosecutor has produced the report, is it?
my lord, that may be clarified because this was the case diary which was retained in the anticipatory bail, my lord.
Yes. Has produced a copy of the case diary which had been retained by the registry in connection with anticipatory bail application 1 of 2026.
Yes, madam.
Isn't it?
Yes.
Stop. Wherein the co-accused Mr. Michael Tajo had preferred the application before this court. Stop. On perusal of the case diary and the status report from the forwarded by the IO of the case, it is seen that the present alleged accused and the other co-accused are similarly situated, and the allegations against them are the same, and they have all been booked under the same sections of law. Stop. This court has also observed that the sections under which the alleged accused has been booked are not serious offenses. Stop. This court has also seen that the co-accused have already been granted bail. Stop. In view of the observations made above, this court is inclined to allow this application, and the accused Shri such and such is hereby released on bail on the following conditions. Number one, execution of bail bond for an amount of rupees 30,000 with one surety of like amount to the satisfaction of the learned trial court. Number two, the accused shall cooperate with the investigation and shall appear before the IO of the case as and when summoned without fail. Number three, the accused shall not hamper the investigation nor tamper with the evidence, and shall not try to influence the witnesses either directly or indirectly. So next, the accused shall not leave the jurisdiction of the trial court without the permission of the court concerned. Okay, so the above directions, the petition stands disposed.
Grateful, grateful.
Madam, CD may be returned, madam.
Yes. The CD is returned back
Yeah.
to the learned additional PP.
Deeply obliged, madam.
Lordship,
Yes.
the next item, Lordship, the petitioner, Lordship, counsel has requested me that he is on the way. So it may be taken up as a last item, Lordship.
Item 3.
Yes,
Item three,
Lordship.
my lord. This is bail application, regular bail application, my lord.
Item 3. Pass
Lord-
over for the time being.
Lordship. Item number 4.
May I please, my lord? My lord, on last occasion, it was withdrawn, this petition was withdrawn due to non-annexure of some relevant documents. So the same has been raised before this honorable court. My lord, this is a joint petition, my lord.
Now you have annexed it.
Yes, my lord, I have annexed that, my lord. This is a joint petition, my lord, filed by the,
Will issue notice.
my lord, my humble submission was that since the FIR was filed out of anger and emotional disturbance, and with the intervention of the well-wisher family members, they have settled the matter. So, and I have annexed all the relevant documents, including the subsequent order passed by
No,
the.
still the CD is required. No?
Okay, okay, my lord.
Yes, without calling, how can we dispose it? This application under section 528 of the BNSS has been filed, praying for squashing of the FIR dated 10/7/2025, the charge sheet number 81/2025, the cognizance order dated 24/9/2025, and the GR case number 55/2025 in connection with, no, you say, and the proceedings of the GR case number 55/25 in connection with Taporijo PS case number 47/2025 under section 117, clause 2/74/69/3 clause 5 of the BNSS. Stop. The petition has been, the heard learned counsel for the petitioner as well as learned public prosecutor. Stop. The petition has been filed jointly by the accused and the complainants, and on the basis of a compromise deed arrived at between the parties. Stop. Call for the trial court records from the court concerned. Stop. Till the next returnable date, the proceedings in respect of GR case number
55.
such and such 55 of 2025 pending before the Learned
CGM Dapo.
GM Dapo shall remain suspended till the next returnable date. Least after 3 weeks. Least after 3 weeks.
Be a place, my lord.
Item number 5.
My lord, this is criminal petition. Lord, notice may be issued, my lord.
Yes. The instant application under section 528 of the BNSS has been filed, bring for quashing and setting aside of the charge sheet number 2/25 dated 24/10/2025, and the proceedings of the GR case number 13/2025 under section 61 clause 2 clause B /336 clause 4 /337 BNSS, which is pending before the Judicial Magistrate First Class, Panging PANGIN. So, heard learned counsel for the petitioner as well as learned public prosecutor for the state respondent. Issue notice returnable within 3 weeks. Para. The learned counsel for the petitioner shall take steps for notice on the respondent 2, 3, 4, 5, and 6.
Yes, ma'am.
On the respondent number 2, 3, 4, 5, and 6 by inland post document as well as usual process within 3 working days from today. So, list after 3 weeks.
Deplorable. My lord, till returnable that my lord proceeding. may be
You want
started.
interim stay?
Yes, my lord.
Till the next returnable date, the proceedings of GR such and such shall remain suspended.
Obliged. Item number 6.
Have I said call for records? Okay. Yes.
May it please your lordship.
Yes.
Your lordship, this is a joint petition for quashing of FIR number 134 of 2025,
Okay. No.
registered at Naharlagan Police Station under section 318, subclause 4 of BNS, your lordship, and
Well, issue. Where's PP?
Sorry, man.
If there's any objection.
Yes, my lord, this is open, this is not meant
Yes.
because it's
Why?
compoundable.
Why?
Yes.
Oh, compoundable.
Yes,
yes,
madam.
your lordship, only 89,000.
Then why are you filing here?
Yes.
Quashing, your lordship, already case has been registered in
No,
JM.
no, you can file a petition before the concerned magistrate
It's for
for
compounding.
compounding. For compounding.
The only offense is 318 subsection 4, right?
Yes, sir.
Then the offense is compoundable, man.
3184.
My lord, 318 subsection 4.
BNSS.
Yes, my lord. BNS.
BNS. Three one eight.
It's cheating, my lord. The
Ah,
subsection
okay,
4 is
okay.
whosoever cheat and thereby the classification cognizable, non-bailable, trialable by magistrate or fine, class punishment imprisonment for 7 years and fine, compoundable by the person cheat with the permission of the court.
Then you file a application jointly,
Yes, this is a joint.
Joint
That's right.
application, but
Yes,
not
it-
before this court.
not here, joint application before the JMFC or CGM, whoever it may be.
All right.
Okay.
Okay. Your
The counsel for the petitioner, Ms. Such and Such, also heard learned petitioner public prosecutor, Mr. T. Stop. Para. This is an application under section 528 of the BNSS spring for quashing of the Naharlagun PS case number 0134/25, registered under section 318 clause 4 against the accused person. Stop. Para. At the outset, the learned additional PP has submitted that section 318 clause 4 of the BNS is a compoundable offense, and therefore the present application is not maintainable. Stop. Para. This court has taken note of the submission and accordingly is of the view that this application is not maintainable as section 3184 of the BNS is a compoundable offense. Stop. Accordingly, the petition is dismissed as not maintainable. Stop. However, the petitioner is at liberty, the petitioners are at liberty to file appropriate application before the competent court.
Yes, ma'am. Deeply obliged.
Deeply obliged.
Item number 7.
My lord. My lord, on the previous hearing, as my learned senior has rightly pointed out, that the victims' names were not mentioned in the compromise deed, my lord. And as my lord has guided me that it's of utmost important with respect to the procedural aspects. Yes, my lord.
Yes.
And my lord, my lord may kindly come to page number 48.
Page
Page number 48, my lord.
48.
Yes, my lord. My lord, I have humbly complied with the same, and the victims' name are now mentioned in the compromise date, my lord. No, my lord, my only humble prayer is
Okay.
that
Yes.
all the criminal proceedings may be quashed.
No, but we will have to see the trial court records, no?
Yes, my lord.
What stage is it?
It's
The
in,
case? Trial stage.
yes, my lord. Appearance is on
Trial
5th.
has started.
Yes, my lord.
Okay.
My lord, may kindly please.
The present application under section 528 of the BNSS has been filed jointly by the accused persons as well as the complainants and the victims. Stop. Para. The learned counsel for the petitioner is present as well as the learned additional public prosecutor. Additional or PP? Learned additional public
PP.
prosecutors, research and such. Stop. Issue notice returnable within 3 weeks. Stop. Call for the trial court records from the Court of Judicial Magistrate, First Class UPIA, Papum Pari District. Stop. Till the next returnable date, the proceedings of GR case number 349/2017 pending before the Court of Judicial Magistrate, First Class UPIA, Papum Pari shall remain suspended. Stop.
My lord,
Yes, please stop
That-
3 weeks. Yes.
it's their first appearance on 5th of
No,
February.
that's why I've suspended. Proceedings are suspended.
Highly obliged, my lord.
Obliged.
Item number 8.
Lordship, in this matter, leading counsel is out of station. Can this matter be fixed after 2 weeks, Lordship?
Her learned counsel, Shri such and such,
JG,
who submits that the leading counsel is out of station.
out of
Out
station.
of station, and accordingly, prays for listing the matter after 2 weeks. The learned counsel for the opposite party has no objection. List after 2 weeks.
No. Obliged, Lordship.
Item number 9.
As per interim granted, he appeared before the IO and bail was executed.
My lord, the one very serious issue is here, my lord. CD we have received, my lord. Here, the state in status, my lord, it has been reflected by the IO that during the course of investigation, an order was passed by the Honorable JMFC UPI directing the initiation of investigation against co-accused Bengia Nachung and Advocate Tai Kumar for criminally intimidating the victim to give a false statement before the magistrate. In compliance thereof, the statement of the both co-accused were recorded under section 180, my lord.
Your in this record, I have annexed page number 26 to 31. The victim himself called the accused person and family for settlement of the case. But after that, the settlement was not done. They intentionally given the statement before the IO and JFC to cancel the bail before this learned court, learned session court. which was already I pleaded in the court when the interim was granted.
Investigation and order was passed.
On the basis of that, the interim bail was rejected by, by the learned session court when the
Otherwise
No,
also,
that was earlier.
yes.
That was earlier. But now
but-
the latest status report, it's a different thing again.
and my lord, otherwise also, my lord,
Intimidating the victim to give a false statement before the magistrate.
That was earlier.
The statements of court purpose. No, is this a recent development?
no,
No,
my lord, that was, by the, basing on that, my lord, the,
And that it
yes,
was cancelled.
yes. And my lord, the second part is, my lord, the second line of argument would be, my lord, this is a pre-arrest anticipatory bail, pre-arrest bail, my lord. In the section, my lord, is a 376 subsection 1, my lord. It's a heinous in nature, my lord. It's against the society, my lord. And so far as, my lord, this section is concerned, my lord.
it's
My
just
lord,
an allegation, my lord.
obviously, my lord, the FIR is allegation only.
This be an allegation.
Allegation only. That's why the presumption of innocence is always there until unless proved, my lord.
Yes.
But whether the question here is whether prima facie material is there or not, my lord. That is the one aspect, my lord. And from the, my lord, that status itself, my lord, to intimidating the victim, my lord. If no such offense has been committed, then why someone will intimidate the victim and say that, okay, you give a false statement, my lord. So prima facie, my lord, the aspect has to be looked into, my lord, whether the offense, because it's against the society also, rape, my lord.
Definitely.
Your Honor, I have annexed in the petition Annexer C, where the victim has served the notice for defamation to the accused person. After the defamation was not fulfilled by the accused person, they have intentionally lodged the FIR. And after the FIR, they give a statement, a false statement before the IO, and the bail was rejected by the learned session judge.
My
After that, he again approached before this honorable court to grant the anticipatory bail. As per the anticipatory bail, he given the approached and given the statement before the IO, and no no development was carried out.
My lord, recently, my lord, this honorable court has cancelled the bail of the trial court on the expect that the prima facie consideration for bail are the, my lord, whether the prima facie case has been made out or not, all the materials, whether constitute the commission of the, whether the offense was committed or not, my lord. No doubt there may be fictitious cases, my lord, but here in this case, my lord.
Acha, just let's see the court, that order
Yes, ma'am.
cancelling the pre-arrest bail, that earlier court order of the session judge.
Okay, my lord, that's in page number 24, my lord.
Page 24. Okay. Present such and such. Where is submitted that by taking advantage of anticipatory bail, accuses harassing and threatening the
There are 4, ma'am.
dire consequences. Okay, paragraph 3. Paragraph 3.
IO has produced the case diary as called for. I have carefully perused the same, and it is found from the case diary that since the registration of FIR, the informant victim has been repeatedly reporting that she and her sister are continuously receiving phone from the accused and his family member, pressurizing and threatening them to withdraw the case, failing which they would face dire consequences. If the alleged accused get arrested, it is further pursued from the case diary that despite assurance of safety given by the investigation agency, the accused has continued to misuse the liberty granted by this court. The victim even approached and criminally intimidated by the brother of the accused, namely Bengyam Nachum, with an advocate, namely Tai, who attempted to coerce and threaten the victim to give false statement before the magistrate under section 183 of BNS. Taking cognizance of the criminal intimidation and the inference from the judicial process, JMFC has passed an order directing investigation into the said incident. The victim and her sister was physically assaulted by the associate near the Bank Tinali, and the there is continuous intimidation and violence by the accused person. In
Mm.
view of the above material on the case diary, it is observed that the accused person, namely so and so, have misused the liberty granted to him by this court by an interim interceptory bail ordered at so and so, and as such, it is observed that the accused person is not entitled for such protection of interceptory bail, hence so and so. So, madam, this cannot be
The
ignored, madam.
behavior of the accused
Yes.
is not very.
Your Honor,
Yes, madam.
that was not done by the accused person and
No,
the
maybe
elder.
not the accused personally, but the brother of the.
Yes, of
brother of
course,
the-
madam.
But my lord, that was already that was allegation, my lord. Because
In 376(1) is a serious offense.
Yes, madam.
But-
Absolutely, madam.
there was not such a incident happen, and moreover, my lord,
No, that is what the
the
accused will always say. That's why investigation is required.
victim himself
madam.
called
Yes.
the accused person and the brother of the
Mm.
accused person
Madam, whether
and called for settlement of the case.
Hmm.
whether
as-
whether my lord, custody is required or not, that is up to the investigation authority. But for pre-arrest bail, it's a privilege bail, my lord. He is not entitled for alleged to be committed this kind of offense and such allegation, my lord, for conduct, my lord. That's my humble submission.
Yes.
My lord, as per the interim granted, the accused person appeared before the IO and
This order passed by the JMFC for initiation of investigation, is
Yes.
it on record? It may be here, no?
Perhaps they have not annexed anything on the not annexed, my lord.
Is it here in the case diary?
Case diary, my lord.
Because that is very serious.
Yes.
If the
May I find it out, my try to find it.
directed for
Yes, madam.
initiation of
Absolutely.
investigation.
My lord, this one, 1712. This is the order of the judicial magistrate first class.
Hmm. Yes, victim has made a statement before the court.
yes.
Yes, anything more?
Your Honor,
Hmm.
the victim herself called the accused person and the elder brother of the accused person for settlement of the case. As because they initially
No, maybe,
Given-
maybe she may have called, you may have called, that is a different issue. But threatening and intimidating,
that was happened during the settlement meeting, but no more
no,
incident was took place
court is
during that
not-
time. But
court is not
and
convinced.
that allegation only based on the circumstantial evidence.
Heard learned counsel for the petitioner, Mr. P.K. Gore. P.K. Gore, right?
Yes, madam.
Stop. Also heard Mr. T.A.T. learned additional public prosecutor. Stop. This application under section 482 of the BNSS has been filed praying for release of the alleged accused Shri Bengia Chabo alias Chunu. Just check from the cost title, okay? For praying for release of such and such on pre-arrest bail in connection with the Itanagar Women PS case number 78/25 under section 376 clause 1/354 of the IPC. Stop. By order dated 23/1 2026, this court had granted ad interim pre-arrest bail to the alleged accused person, and the matter has come up for final hearing today. So the learned public prosecutor has produced the scanned copy of the case diary. Stop. Para. Learned counsel for the petitioner submits that the alleged accused, after this court granted the pre-arrest bail on 23/1/2026, had appeared before the IO of the case when?
At 28.
On 28.
Yes.
On 28/1/2026, and has
Bail was executed.
and bail he was arrested and bail bond was executed. So it is submitted that the accused person has not violated the conditions of the bail, and therefore prays that the interim bail may be made absolute. Stop. It is also the submission of the learned counsel for the alleged accused that the allegation of intimidating the victim during the pendency of the pre-arrest bail and the further cancellation of the pre-arrest bail by the learned session judge by order dated 15/1/2026 was a fake allegation, and that it was the victim who had called the accused person, and the accused had not done anything to harass or threaten the victim. Stop. It is also stated that the pending case being Itanagar Women PS case number 78 of 25 is based on false allegation, as the alleged accused has not committed any such offense. So it is the prayer of the learned counsel for the alleged accused that this petition may be accordingly allowed, and the interim order may be made absolute. Stop. Para. Learned additional PP, on the other hand, has relied on the case diary and submitted that an order has been also passed by the learned JMFC UPIA directing initiation of investigation against the brother of the accused person and one advocate Tai Kumar, TAIKUMAR, Tai Kumar, for criminally intimidating the victim to give a false statement before the magistrate. And in compliance, the statements of both co-accused had been recorded under section 180 of the BNSS. So the learned additional PP has also produced a copy of the order dated 17/12/2025 passed by the learned JMFC UPIA, by which wherein it is wherein it is stated that the victim had categorically stated before the court that she was criminally intimidated to give false statement before the judicial magistrate. Stop. In view of the behavior of the alleged accused person in the present case, and moreover, in view of the fact that section 376(1) IPC is a serious offense which is against the society at large, learned additional PP submits that there is prima facie case against the present accused, and therefore the petition is devoid of merit and may be dismissed by this court. Stop. Para. The court has given due consideration to the submission of the learned counsels for the opposing parties. Stop. This court has also peruse the order dated 15/1/2026 passed by the learned session judge Upia, by which the pre-arrest bail granted to the accused person was dismissed. So the court has also gone through the order dated 17/12/2025 passed by the learned JMFC Upia, wherein it has been clearly reflected by the learned court below that the victim had stated before the court that she was criminally intimidated to give false statement before the judicial magistrate under section 183 clause 6 clause A BNSS by one Shri Bengia Nachung, BANGIA NACHUNG, Bengia Nachung, the elder brother of the accused in the instant case, in the presence of an advocate named Tai, TAI. Stop. The magistrate has also, the court has also recorded that the statement of the victim prima facie reveals commission of an offense under section 351 clause 1 BNS against the brother of the accused person. And in this regard, the OC of Itanagar Women PS was directed to register an FIR and investigate into the matter. Stop. Para. This court has also noted the behavior of the accused person in as much as he had been granted interim pre-arrest bail by the session court on 11/12/2025. Stop. However, 2025 with a condition that he shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case, and that he shall not tamper with the investigation. Stop. However, this court has seen that during the pendency of the interim pre-arrest bail granted to the alleged accused, he has violated the terms and conditions.
Your Honor, that was during that time, madam.
During the pendency of the interim.
But not in this court.
No, I know.
Yes.
I'm talking about that other session case.
Yes.
Yes. Yeah, I'm talking about the session case. Violated the terms and conditions of the pre-arrest bail granted by the session court. Stop. In such a situation, the learned session judge had dismissed the anticipatory bail application of the accused person by order dated 15/1/2026. Stop. This court is also prima facie satisfied that the victim had been criminally intimidated by the brother of the accused person, as the judicial magistrate first class Upia has taken note of the allegation and has initiated the investigation against the brother of the accused person. So, para under such facts and circumstances, this court is of the view that the interim order dated 23/1/2026 passed by this court cannot be regularized at this stage. Stop. Accordingly, the petition stands dismissed.
Your Honor,
Earlier order vacated.
Yes, yes.
Yes.
The interim order passed earlier shall stand vacated.
Yes. Obliged.
Return the case diary is returned to the learned edition.
my lord,
Deeply obliged.
the accused person given the further statement before the IO, and there were no objection regarding the bail was rejection on that ground, because in this case, my lord,
No, you
I'll-
can always file subsequent bail application.
yes,
The liberty is always there.
Your Honor, I have annexed the call records of call.
Yes, yes, yes.
Yes.
Court has seen that also. We have
Yes, my
seen.
lord.
Mhm. You file again after some time.
Obliged, madam.
You file for regular bail if required.
Obliged.
Item number 11.
Yes.
May I, Your Lordship?
Ah.
I appear on behalf of Utica for respondent number 1.
Appellant is not there. None
No.
appears for the appellant when the matter is called. Learned counsel, Miss Such and Such, appears for respondent number 1. The trial court records have been received.
Your Lordship, on the last occasion,
Hmm.
appellant has seek some time to file, serve notice upon the respondent number 2.
That affidavit has not been filed.
Yes.
The trial court records have been received. Stop. Para. By order dated 4/12/2025, the appellant was directed to file an affidavit including the copy of the newspaper on which through which the substituted notice on respondent number 2 was served. Stop. The affidavit has not been filed as yet. Stop. List the matter after 2 weeks.
Deeply obliged.
Item number 13.
Yes, what is this?
Oh, if I may, you know.
Yes.
Hello.
You are for the
Yes.
petitioner.
Yes, I'm for the applicant in this particular IE.
Applicant,
Yes.
you have taken steps. You have taken steps for R2.
Yes, I've taken steps out too, but the thing is that I have not yet received this thing AD cards, Your Honor.
No, you were
Because-
supposed to take steps by Dusty.
Yes,
On
I have
R2.
done it, Your Honor. I have not filed the affidavit also, Your Honor, today.
You have to file affidavit. That means
Yes. I have not
heard learned counsel for the applicant, Mr. A. Talo.
Your Honor.
A. Talo. Stop. Also heard anybody for the respondent.
On the
None
last
appeared.
occasion, counsel appeared for respondent number 1.
Today nobody is there. None appears for the respondent number 1 today.
Yeah.
Stop. The applicant, the learned counsel for the applicant submits that he has not yet filed the affidavit in respect of the Dusty service on respondent number 2. Stop.
Yeah.
Accordingly, list the matter after 2 weeks or 3 weeks.
If possible, Your Honor, since I am an outstation advocate practicing out here at Pasighat, if a fixed date can be given, it will be much obliged, Your Honor.
Okay, list the matter on.
If
You give
possible,
a date then
16th of March, Your Honor.
on 16 March.
Yes, Your Honor.
On 16/3/2026. Stop.
Your Honor.
Before the next date, the applicant shall file the affidavit regarding the service on respondent number 2. Okay.
Obliged, Your Honor. Much obliged.
Item number 14.
14. Mediation, madam.
Letter may be sent for mediation.
It can be sent.
Yes, my lord. All the offenses are compoundable, my lord. They are challenge on merit. Let them.
Heard learned counsel for the petitioner, Mr. K. Dolen,
Yeah.
as well as Mr. T88 learned additional PP and
M. Ratan
and
for respondent
M.
number 2,
Ratan
my lord.
for-
Private respondent.
for respondent number 2. With the consent of the parties, the matter is referred for mediation to the Guwahati High Court Itanagar Bench Mediation Center under the nationwide mediation drive. Stop. The parties shall appear before the mediator when? Shall appear before the mediator on?
Let it be on 12, my lord. 12.
On 12/2/2026, and the mediation and undergo the mediation process. So
That's obliged.
Item number 3 is a passable matter.
My Lordship.
Hmm.
So, Lordship, this is a case where I had been in custody for last 138 days.
Mm.
Meanwhile, the bail was pending before the special court, SIT UPIA.
Mm.
So, one of the interesting part in this allegation is regarding the initial arrest was based on the
This is coming up for motion, isn't it?
yes, Lordship.
So,
So, but Lordship, as per the record, I will satisfy this Lordship. That as per the record,
Mm.
remaining alleged accused are on enlarged on bail. Now, apart from
whatever
that,
it may be,
yes, and
without going through the CD, how will the court know?
My lord, this year, my lord.
Just your statement. This year.
This year, yes,
Charge
charge sheeted, my lord. Yes, ma'am.
Okay. Okay.
even though Lordship, even though in charge sheet also, there is a, if Lordship is aware, because all those alleged accused has been granted bail based on the
Okay. So on the next date, if the court sees that the co-accused have been granted bail, then on the ground of parity, the court may consider.
My lord, my lord.
But without seeing the trial court records, how can I do that? This application under Section 483 of the BNSS has been filed, praying for release of Shri Biri Ruja, BIRIRUJA, on regular bail. In connection with Nirjuli PS case number 77/2025 under section 308 clause 2/61 BNSS, read with section 13 of the UAP, Unlawful Activities Prevention Act. Stop. What is this? There are two cases. One
Yeah.
is Nirjuli PS, one is SIT case.
yes, Lordship. One is SIT, where I had been arrested for 308 clause 2. Subsequently,
Okay.
I had been arrested in another case
So
in same means extortion note, where I'm not involved. But in that case, I had been granted bail by the special court.
Acha, in this SIT case, bail already granted.
No. In
Not granted.
Nirjuli PS case, both are from same PS.
That Nirjuli PS case, bail granted.
Yes, 82. That both are from same PS, Lordship.
Okay, and
77,
and
ma'am.
also SIT case number PHQ/CB PS/NRJ FIR 77/2025. Is that right?
Yes, ma'am.
77? Yes. Okay. Learned counsel for the petitioner, Shri such and such. Stop. Learned additional PP or
My lord,
special?
SPP,
Learned
special public,
PP.
SIT.
SIT.
El Kurdu.
Else such enters appearance on behalf of the respondent. Stop. Issue notice returnable in when can you produce the text?
Lordship, here actually the question is that whether they had served that notice as per the section 35 of BNSS as well as 47, 48. So those records are available in this petition also because they had not served those. So just that only they have to verify.
Notice returnable in 2 weeks. Stop. The registry shall call for
Lordship,
the
date may be
trial court records.
fixed, yes.
The registry shall call for the trial court records from the court of which court?
Session court, my lord.
From the
Session court, UP, my lord.
session judge, from the court of session judge UPIA. Stop. List on
5th of February.
on 5 No, that will be
Lordship.
next week.
Next
Yes.
week, my lord.
Lordship,
Don't say 2 weeks then. Notice, issue notice returnable on 5th February.
and even record might be there in before this GR branch of JMFC also, because sometime
No, the T-shirt will be needed, my lord. It is only
that's
in the
T-shirt,
T-shirt.
yes,
Yes.
T-shirt, charge sheet,
Yes, ma'am.
Lordship.
Obliged, ma'am.
On 5th.
Lord,
Yes.
My lord, may I kindly see the, my lord, the service report, my lord. The service was not caused to the accused, my lord. It's to the brother, my lord. It is supposed to cause to the accused, my lord, in this criminal case, my lord. My lord will find the flag mark there, my lord.
Returning of notice. Oh, it was served on the brother of the
Yes, my lord.
respondent.
It's not, service is not complete, my lord, in that case, because it is served to the accused person only, my lord.
You take steps again?
Lordship.
Yes. Learned counsel for the petitioner is Lolen, no? Is present. Stop. Learned additional PB, Mr. T. is present. Stop.
Jurisdictional PS police station. Local island.
It appears that the service report in respect of the respondent number 2 has been received by the brother of the respondent number 2. Accordingly, the learned counsel for the petitioner is directed to take fresh steps for service on the respondent number 2 himself.
Lordship, service through the concerned jurisdictional
Through PS.
PS, it will be better.
Okay, through the jurisdictional police station. Stop. The learned additional PP shall also produce updated case diary on the next date.
Yes.
Yes.
Next date.
What did I say regarding next date? Fix on? Okay. Okay. Date, do you want the fixed date or will
Fix that, Lordship.
Let it be on 19th February.
fixing 19th February 2026?
Obliged, my lord.
Deeply obliged.
Okay, thank you.
Lordship.
He published new. If I present
सर को फोन करके बता दीजिए ऑनलाइन भी किया है सर अभी क्या करेगा वो अगर वो बोलेगा कि
No, that is one kind of no आराम में no क्योंकि no वो हाथ जाएगा न्यारी का हाथ जाएगा तब ये ना एफिडेविट पुलिस को जो है ना एक आदमी साथ में रख के फिटनेस कराने देना है कि रिसीव नहीं कर रहा है हमें वो घर में नहीं रहते सर करना पड़ता है उसके बाद हम लोग एफिडेविट नहीं करें उसके बाद वो क्या बोलते हैं प्रोसीड करेगा मैं क्रिमिनल का बहुत जाम है सुप्रीम कोर्ट में उड़ा देगा 5 तक हां किसी गलत प्रॉब्लम ये जो ऐसे होता है एक साल ज्यादा मेरिट में क्वेश्चन जा रहा है मेरा भी तो हम बोले वो एक एग्रीमेंट में उसने इसका बोल के एक मिनट ऐसे हाँ वो मेल दोनों एक्यूज और मालिक सेटल भी हो गया लेकिन हमको नहीं नोटिस आने से बोलते और रिसीव नहीं करते उसको छोड़ो ये जो ये आपका विलास पार्टी वाला उसका को आप कब कर रहे हैं एक GST मार्टिन फ्यूचर गेमिंग वाला कंपनी हाँ हम नहीं है लोकल कंपनी वो लोग कितना आप इतना कंफ्यूज नहीं हाँ लोकल कंपनी फोन करते हैं पहले लास्ट आवर में टाइम नहीं तो बोलते हैं ना वो बॉस क्या था चौधरी हाँ चौधरी
वो लोग
इसलिए ना थोड़ा कंफ्यूज है, तो आपको कोऑर्डिनेट करना है ना उन लोगों को करना
उन लोग को करना नहीं, कुछ एफिडेविट वो सब देना और हम रिसीव करके उन लोग को स्कैन कर देते हैं केस ऑफ एनी। हाँ, यहाँ पे आप फिजिकल कम्युनिकेशन को हमको दे
कि वो और एक सर है ना, क्या नाम था वो जो बेल करने कराने वाला, ये जो क्या नाम था वो